Trust isn't just a feeling, it's a powerful legal tool. In Alberta, trusts are used to protect and manage assets for others, not just the wealthy. Trusts help families pass down inheritances, support charities, and plan for the future. At its core, a trust is a promise. One person holds something valuable for another, bound by law. Think of it as a vessel carrying assets safely to their intended recipients, even after the original owner is gone. Alberta's trust law sets clear rules for creating, managing, and benefiting from trusts. Trustees must act honestly, and beneficiaries can hold them accountable. Trusts aren't just for big estates. They're practical for education funds, special needs, or small business succession. They offer control and protection that other estate planning tools may lack. Let's break down how trusts work, who's involved, and why they matter in Alberta. Every trust has three main players: the settlor, the trustee, and the beneficiary. The settlor creates the trust, transferring assets and setting the rules. The trustee manages those assets, holding legal title, but acting solely for the beneficiary's benefit. Trustees can be individuals or institutions, but they must always act with loyalty and care. Beneficiaries are the people or organizations meant to benefit from the trust. They hold the right to enjoy the trust's assets or income, as outlined in the trust document. This separation, trustee as legal owner, beneficiary as true recipient, is what makes trusts unique. The settlor's vision, the trustee's duty, and the beneficiary's rights form a triangle of responsibility. Each role is essential. The settlor sets the plan, the trustee manages, and the beneficiary receives. This structure allows for professional management and ensures the settlor's wishes are honored. Trusts balance control, protection, and benefit for everyone involved. For a trust to be valid in Alberta, it must meet the three certainties. First, certainty of intention. The settlor must clearly intend to create a trust, not just make a gift. The language must show a binding obligation, not just a wish. Second, certainty of subject matter. The assets going into the trust must be clearly identified. Vague statements like, "Some of my assets won't work." Specific property must be named. Third, certainty of objects. The beneficiaries must be clearly defined. The trustee needs to know exactly who benefits, whether it's named individuals or a defined group. If any of these certainties are missing, the trust can fail, and assets may revert to the settlor's estate. For charitable trusts, the purpose must be clear, even if the beneficiaries are a broad group. These certainties ensure trusts are enforceable, transparent, and fair. Without them, trust law would be unpredictable and open to abuse. Clarity is the foundation of every valid trust. The settlor is the architect of the trust, deciding what assets to include, who benefits, and who manages. Trusts can be created during life, inter vivos, or through a will, testamentary. An inter vivos trust is set up with a legal document and takes effect immediately. A testamentary trust is written into a will and only activates after death. The settlor's instructions, how assets are managed, who gets what and when, are crucial. Clear, detailed directions prevent disputes and ensure the trust runs smoothly. The settlor's work is mostly at the start, but their decisions shape the trust's future. Whether for children, spouses, or charities, the settlor's vision guides everything. A well-drafted trust is a lasting legacy. The trustee's role is one of utmost responsibility, governed by fiduciary duty. Trustees must act with loyalty, prudence, and impartiality, always putting beneficiaries first. They can't profit personally unless the trust allows it, and must avoid conflicts of interest. Trustees must manage assets wisely, keep detailed records, and report to beneficiaries. If a trustee fails in their duties, beneficiaries can take legal action for breach of trust. Courts can order compensation, remove trustees, or even impose criminal penalties for serious misconduct. This strict accountability protects the trust and those it's meant to benefit. Trustees are guardians of both assets and intentions. Beneficiaries are the heart of any trust. They hold the right to benefit from its assets. Their rights are defined by the trust document and protected by law. Beneficiaries can demand information, see the trust document, and request formal accountings. If a trustee mismanages the trust, beneficiaries can go to court to enforce their rights or seek the trustee's removal. In some cases, all adult beneficiaries can agree to end the trust early and receive the assets directly. This power ensures beneficiaries aren't just passive, they can actively protect their interests. The balance of trustee duty and beneficiary rights keeps trusts fair and effective. Trust law gives beneficiaries real power, not just promises. Trusts in Alberta come in many forms, each serving a unique purpose. Express trusts are created intentionally, with clear terms, like family trusts or testamentary trusts for children. Charitable trusts support causes like education, poverty relief, or community benefit, and can last indefinitely. Resulting trusts arise when property is transferred, but not meant as a true gift. Courts step in to clarify ownership. Constructive trusts are imposed by courts to prevent unfair enrichment or correct wrongdoing. These court-created trusts aren't planned, they're remedies for justice. Each type of trust has its own rules, but all share the goal of managing assets for others' benefit. Whether planned or imposed, trusts are flexible tools for fairness and protection. Alberta's trust law adapts to many situations, from family planning to resolving disputes. The right trust depends on your goals and circumstances. Alberta's trust law is shaped by statutes and the courts. The Trustee Act sets out trustees' powers, duties, and standards, like investing prudently and keeping records. Trustees can ask the court for guidance if they're unsure about their duties. The Wills and Succession Act governs trusts created by wills, ensuring they're valid and fair. The Court of King's Bench oversees trust disputes, trustee conduct, and interpretation of trust documents. Court decisions and statutes together form the backbone of Alberta's trust law. This legal framework keeps trusts running smoothly and resolves conflicts. Trusts are grounded in both written law and real-world judgment. Most trusts are designed to end at a set time or event, as specified by the settlor. Trustees distribute assets when the trust ends, like when a child turns 25 or a spouse passes away. If circumstances change, the Court of King's Bench can approve changes to the trust for beneficiaries' benefit. Adult beneficiaries can sometimes end a trust early if they all agree, taking control of the assets. Trusts aren't just for the wealthy. They help Albertans protect loved ones, support causes, and manage assets wisely. From special needs planning to business succession, trusts carry intentions into the future. A well-structured trust is a powerful, flexible tool for security and care. At its core, trust law is about turning promises into lasting protection.